We wanted to spend a few minutes reviewing fair housing and anti-discrimination laws, and regulations and responsibilities. That HUD has a long history of, no, maybe not long enough, but they have had a good history in the last couple of decades around anti-discrimination and enforcement. Federal laws that prohibit discrimination are, very attentively addressed. The HUD's Office of Fair Housing and Equal Opportunity is the primary resource for that. There's also a lot of resources on the Department of Justice website, and they have collaborated on a number of documents, including some of the Olmstead guidance that I'll be talking about later. Primarily, they work to eliminate housing discrimination, promote economic opportunity, and achieve diverse, inclusive communities. The Fair Housing Office has the civil rights authority over housing-related programs. And so that means that they have a legitimate right to understand the details of operations, among other things. Anti-discrimination and HUD-assisted programs is based in these laws. And again, I'll talk a little bit more about them when we get to the Olmstead section. Of the HUD Act. All of these things together are the basis upon which we all operate, and the basis upon which HUD requirements are written, and where their enforcement is focused. So we're looking at federal protected classes. So race, color, religion, sex, including gender identity and sexual orientation, national origin, familial status, and disability. And again, when we get to the discussion of Olmstead, I'll have more to say about disability. Demi, you want to take it? Oh, we still cannot hear you. You are frozen. So I'll go on. So the Fair Housing Office, this is who they cover. And I think we all know that. So I'm just going to move on because we've got some great case studies that we want to talk to you about. But first, as Demi threatened, we would like you to name a protected class. You can do that in the chat or a Q&A. And I'm not sure how to see that, so you'll all have to tell me. Is that going on?
Yes, we have some race, familial status, sex, religion. Looks like we've got all great answers in there.
Okay, cool. All right. I was hoping somebody would say disability, but we are gonna.
We do have a couple of those.
Okay, good.
We have gender.
Okay. So let's take a look at the story of Bob. Are you back, Demi?
I hope so. I'm so sorry. I'm in the desert and the storm happening, and we've been without power for a little bit. Up here in the Palm Springs area, it's a huge windstorm. So good. I see disability. Some folks put disability in the chat. So we're going to talk about Bob, and thank you so much, Anne, for jumping in.
Dr. Hill, may we just try and just turn off your camera? I apologize for having you do that, but it might reduce the use of your internet. All right, Anne, I think maybe if we move on, we'll have Dr. Hill jump on and maybe not have her turn on her camera, because sometimes
okay.
Use her.
All right. Well, I can go on. I know our time is, everybody's time is precious. So let's look at Bob. He was prioritized for permanent supportive housing which is something that we know a lot about at AHP. But when the housing specialist ran his background, he was arrested twice in the past year, once for disturbing the peace and once for public intoxication. And so the housing specialist looked at the admissions and continuing occupancy policy, ACOP, and noted that Bob was not eligible for housing due to his criminal history because it was recent. Bob's shelter caseworker found out Bob was denied housing and sent a note to the PHA, making the case that Bob has mental illness and that he was experiencing chronic homelessness. And the caseworker noted that the two arrests were related to his mental illness and the criminalization of homelessness, and that Bob has been successful in treatment. All right, and so we're back to Demi's quiz. What should the housing specialist do next? Request more information from the shelter caseworker, follow the ACOP and notify Bob that he's ineligible and his right to appeal, call the housing supervisor and give him a copy of the letter from the shelter caseworker and ask him what to do, or make a reasonable accommodation and waive eligibility requirements for Bob since his arrests were related to his mental illness.
So we have a few different answers. We have number 4, we have a couple number 2s, we have a number 1, number 4. Someone has 1 and 4, trying to increase their odds of getting that answer right. Number 4, 2, so definitely not a majority here. It's kind of across the board.
Okay, Demi, you want to
Really?
talk about that?
Sure, really interesting. Okay, so it looks like we've got a lot of 4s, 2s. Follow the ACOP. That's like our guide, right? Can you advance to the next slide?
I can.
So the answer is really 5. It is none of the above. So HUD's Public Information Notice 2015-19 clarifies that the fact that someone that has been arrested does not in itself prove that the person has engaged in a criminal activity. And as a result, the fact of an arrest is not an acceptable reason for denying a person for admissions, terminating their assistance, or even evicting somebody in public or federally assisted housing. And in the next slide.
Working on it.
So technically you could have done a reasonable accommodation, in this case, however, due to the Fair Housing Act. But if you're asking about whether a person has a disability or the nature of a disability during the application process, you could potentially be in violation of fair housing, unless this is a disabled housing complex where everybody in the building has some sort of disability, and that is a qualifier for you to be in that housing. So refusing to grant a reasonable accommodation in that case could be a challenge. However, placing different terms or conditions on housing because you lived in an institutional setting, or requiring somebody to provide more documentation or additional screening approval processes could be a violation of the Fair Housing Act, or imposing stricter criteria, etc. So going to that shelter worker and asking for more information, getting more information about that disability. The path of least resistance would be to follow HUD's HUD's information notice, public housing information notice around criminal activity, which is newer. But folks have got to learn that, because we could inadvertently be discriminating against people. And in the next slide. So Bob's recent arrest should not be grounds for the eligibility denial. The reasonable accommodation could be provided. However, based on HUD's guidance regarding arrest, this is a slippery slope, because there's no consent between the shelter and the caseworker and the public housing authority for this information, nor should the staff ask for more information regarding Bob's disability. So you guys did great. I love your answers. I think we could have got there. But I want to make sure you guys are noting that you've got to do your homework on HUD's guidance around arrest and the criminalization. We're going to move on to Marigold, and I love Marigold. I love this story. And by the way, the last story was an actual true case. And so the bottom line is some of these are real scenarios. And so Marigold is an 82-year-old senior citizen. She's been living in public housing for 6 years. Her son visits all the time, and he brings his 2 large pit bulls. Sometimes they can be heard barking. They've resulted in a noise complaint by a tenant 9 months ago. And Marigold has also received 4 violations over the course of the years that she's lived there related to unauthorized visitors and pets. Marigold had a housing inspection. It was her annual inspection. And the inspector noted that there were 2 dogs locked in a cage. And Marigold told the inspection team that her son went to prison. The dogs were all that she has now to keep her company, and that she's often very lonely and has no visitors. The inspector noted that there was a chewed up corner of the kitchen cabinets, some scratches on a bedroom door, which he thought was caused by the dogs. And this project has a no pet policy because it's a very small project and there's no outdoor area for pets. So what should the PHA and property manager do next now that they've seen that inspection? So these are the issues, right? We've got these dogs. There's some potential damages to the unit from the dogs. There's been noise complaints in the past, and there is a no pet policy. Somebody's saying, yep, 1 is the issue. Can you go back real quick, Ann?
All right.
Identify the issues, but which ones do you think are the biggest issues? Drop it in the chat, 1 through 4. Some of the biggest issues: noise complaints, pet policy, 2 and 4. Okay, damages to the unit, 2, 3, and 4. All of them are issues. That's true. They are all issues. But if we go back, can you go back, Ann, 1? I just want to note, when you look at, somebody says 4, 1, 2, 3 in that order. Okay. When you look at Marigold, she's a senior, right? She's been living there. It looks like her noise complaints were 9 months ago. But she's had 4 violations over 6 years. So is the noise complaint an issue today? No, because it was 9 months ago. Are the dogs causing any problems there? As far as making noise, at this point, we can say no. Are the dogs causing problems and potentially damaging the property? I think the answer would be yes. And we have a no pet policy. So she kind of got left with these dogs. Her son is gone. And now what do we do, right? Got these 2 dogs. And if you could advance the slide to the next slide. In Marigold's case, what are the chances that she has a disability? Drop in the chat if you think she could potentially have a disability. If you look at her age, somebody says, hi, yes. Yes, who wants to evict Marigold? Who would feel good about evicting Marigold? She's in her 80s. She's been living there 6 years. She's not having complaints at this point. Somebody says can't evict. Could we potentially make these dogs an accommodation, right? This is the route that I would go. Now we are talking about accommodations, right? Yes, people are saying yes, because nobody wants to see Marigold on the street, right? So how do we solve this problem? How do we accommodate Marigold? With her being that old, and she's saying these dogs are the only things that she has left to keep her company while her son is in prison, they could be some sort of support for her, right? And federal law doesn't protect support animals. It does protect companion animals. However, certain states do allow for support animals, emotional support animals. So if you could advance the slide. Which one of these is a service animal? Is it the doggy, the birdie, the miniature horses, the bunnies? Somebody says all. Could be any of them. Dog and a horse, dog and a horse. Let's see, all could be dog and mini horse. Either one could be, okay. help her find someone to exercise her pets. Okay, yeah, I like that idea. Aw, dog. Okay, so somebody says only a dog. Your pop quiz. You guys are doing all of the above except a horse. Okay, if you can advance the slide to the next slide. You guys are doing great. I'm so glad you're awake. You were told we were the brightest and best, and I believe it. Under the Fair Housing Act, an assistance animal. What is an assistance animal? So an assistance animal is two types: service animals and other trained or untrained animals that do the work to perform tasks, provide assistance, and or provide some sort of emotional support for individuals with disabilities. A assistance animal is not considered a pet. And individuals with a disability may request to keep an assistance animal as a reasonable accommodation to pet restrictions. And a housing provider cannot refuse to make a reasonable accommodation in its rules, practices, or services if this person with a disability needs the equal opportunity to enjoy a dwelling. So under federal law, two of them, go ahead, Ann, you were right.
Okay.
Thank you. Two of the animals are considered protected or that are allowed accommodation, and it is the dogs as a service animal and a miniature horse. Can you believe that?
Yeah.
Google it if you don't believe me. It is a miniature horse. And we actually had in Vermont, they actually had a case of somebody that had a miniature horse and they had to provide some accommodations. So if Vermont is on the line right now, I was so glad to hear that you guys actually had a case, because I was like, what happened? Somebody requested an accommodation for a miniature horse. Yes, these are federally protected, the animals. And no, so no, you can't have your 19 rabbits unless your state says that you can have the 19 rabbits. And I actually had a case one time, it was actually 17 rabbits, but that's a whole nother story. Bottom line is your state could have laws that expand above and beyond federal law, but according to the federal government, these are the two animals that could be considered service animals if they have the specific training. And then the next slide. A housing provider can ask an individual to provide some sort of documentation for an accommodation. But in Marigold's case, would we need to? I mean, she's in her 80s. Do we have to make her go through the rigmarole of providing documentation that she needs these animals? Could we just give her the accommodation? Do we have the ability to do that? And the answer is yes. If we think she needs the accommodation, we do not have to put her through, we need a doctor's note. We need this and we need that. We could actually give her the accommodation. If the dogs aren't causing problems and they're not, noise complaints that are current, and they're not creating issues in the community, we could potentially just give her an accommodation. We could also consider moving Marigold to a place that does allow pets, right? That's an option as well. Maybe, this isn't the appropriate location for her, and we can find a location where she'd be willing to move to that would allow the pets. But the bottom line is, we do not want Marigold out on the street. So a housing provider could ask for documentation, but it is not required. And so who is a person with a disability? Some of it's readily observable, others can be invisible. So you don't know who a person is with a disability, and you can't guess, meaning you can't look at somebody and say, do they have a disability or don't they? In the long run, if somebody tells you that they have a disability, you need to believe them. And if you live by that rule of thumb, then you should be protected in the sense of liability. If you believe them and you trust that they do. And it doesn't mean every single person that you'll need documentation. And I think that's something that's important, because you could be inadvertently discriminating against somebody if you don't believe them and they tell you that they have a disability. But disabilities have, activities that are important to daily life. They include walking, speaking, hearing, seeing, etc., and caring for oneself. And there's a lot that aren't on this list, and Anne will talk about those in a little bit.
Dr. Hill, we just have a couple of questions regarding the animals before we move on,
Okay.
if that's okay.
Let me get to what about the damages? Okay, is that the question? Let's see here. What about the damages? Well, in this case, there's some scratches, a little bit of biting, right? So the inspector comes in and says, you've got these damages though. What would you normally do if somebody has damages that are above and beyond wear and tear? Typically, you fix them and you bill the client. Somebody says charge them, right? So in this case, that's what you would do. You would do what you normally do. So the goal is to keep her housed though, right? Our job is to house people in the safe, in a safe environment, in a manner that's consistent with our program policies, etc. So at the end of the day, and somebody says, but aren't you opening the door for more requests? You could be, but if people have disabilities, it is the law that you honor those requests, right? It is not optional, right? Fair housing is to protect people with disabilities. And somebody says a more pet-friendly environment. How many of you have pets? I bet you more than, 75% of you, if I can get, the reaction, I bet you more than 75% of you have pets and they bring some sort of joy to your life. That's why you have them. And that's why I don't, because I have kids and I don't want more pets. But at the end of the day, a lot of people are pet people. So at the end of the day, the goal is to get folks housed, keep them housed. And if there's damages, you should charge her the same way that a regular landlord would do. Are there other questions we need to address? I'm trying to check the chat here.
There was just one question regarding liability, which I can answer. We have had claims, and all claims are different, so it's very dependent on the situation. But we have had claims in the past where a tenant has had a dog that has bit another resident or a visitor on the property, and the housing authority has gotten brought into those claims. So yes, the housing authority can sometimes be held responsible for incidents that may occur on the property. It does depend on the situation and a bunch of varying factors. But I just did want to answer that question.
I hear you, Beth, and I think that's, par for the course, right? In normal life, that can happen as well, where your neighbor, you go visit your neighbor and something happens.
Right.
So I think, we're talking about animals that, and somebody's saying, but what about the breed, right? Here's an issue. And so according to HUD, we cannot determine the breed, right? We're not allowed to say you can have this type of dog, but not that type of dog. And in the risk situation, Beth, I'll let you speak to that, but according to HUD, we don't get a choice of the type of dog that a person gets to have as a service dog.
Right. And if there are any specific questions regarding your policy, I do recommend reaching out to your account service rep, and they can go through their policy with you, because we don't answer, questions regarding specific incidents that may occur, because there could be some varying policy coverages. So if anyone does have a question regarding their own individual coverage, I do recommend that they speak with their account service rep or their agent.
Awesome. I think that's a great answer. And so who is an individual with a disability? It's somebody who potentially has a limit to major life activities with a record of such impairment, or who is regarded as having such impairment. And somebody listed some of these in the chat I saw a little bit earlier, but conditions could be orthopedic, visual, speech, hearing, cerebral palsy, autism, epilepsy, HIV, developmental disabilities, mental illness, drug addiction, and alcoholism. So these are considered disabilities by HUD. And in the next slide, there's also Section 504 of the Rehabilitation Act, which means that people can't be discriminated against in outreach and public contact, in the eligibility criteria, the application process, the admissions to the program, in their tenancy, including eviction. So this is where it could become an issue potentially with Marigold, and in the service delivery or physical access to the facility, and in employment practices and policies. So if our job is to keep people housed, then that's what we should be doing. We should constantly work from that lens. How do we keep people housed? Great. You guys are doing a lot of, is asthma a disability? Yes. Somebody asked if asthma is a disability. Yes, it is. Okay, moving on. We're going to do another case study with our brightest and best. So this is Denise. So Denise was on the list for public housing for 7 whole years, and her name finally came to the top of the eligibility list. She was invited by the Public Housing Authority to bring in all her documents to a housing event where several vouchers were made available to people who were on the list. So they wanted everybody to show up, bring your documents. We're going to do a housing event. So Denise submitted all the required documents to the PHA, except for the Social Security cards of her 3 children. And in the next slide, PHA worker called her and said, hey, where's your Social Security cards for your kids? I need to process your application. And Denise advised the worker that she had experienced intimate partner violence 4 years ago, and that her children's father had recently got out of jail and he was looking for her and the children. So Denise refused to provide the Social Security cards to the Public Housing Authority worker, and the PHA denied her eligibility due to not submitting all of her documentation timely. And then the next slide, does the eligibility denial align for Denise refusing to provide the 3 Social Security cards? So basically, did the PHA do the right thing? Yes, no, in part, or I am unsure. Drop it in the chat. No, yes, no, I'm unsure. No, in part. I'm unsure. 3 in, okay. Yes. Somebody says, what about VAWA? No. Somebody else said VAWA protections in part. No, no, no. All over the place. We've got mixed answers, which is really cool because somebody says it depends. I'm unsure in part. So this is an actual case study that was enforced by HUD's Fair Housing and Equal Opportunity recently, within the last year or so. And the housing provider refused to rent the unit to a survivor due to non-disclosure of her Social Security cards due to safety concerns. So HUD found that the PHA could have truncated the Social Security numbers. In other words, they could have, somebody said, are the numbers should be sufficient? She didn't want to provide the numbers or the cards, the information at all. And HUD said that you could basically, instead of requiring that she provide the Social Security numbers, you could take the information and truncate it, meaning in the data, make it a John Doe where you don't know whose name is tied to these numbers. So there's a way to truncate information to make it private, keep it confidential to where it is not shared, because there are challenges with safety concerns when we're talking about people who have experienced intimate partner violence. Now, can we go back and not forward? Can we go back 2 slides?
One more?
One more. Are you able to go back one more?
Oh, I'm sorry.
One more again. Thank you. One more. I want to go back to the case study itself.
Okay,
Now,
right there.
I often get this question. Now it's too far back, but I'll go to the case study. There we go. She was on the list for 7 years. She was asked to bring her documents. She did not bring the documents for the 3 kids. Go to the next slide, Ann. How long ago did the violence occur?
Wait.
4 years ago. So what are your thoughts on that? This happened 4 years ago. It's not like it was today. It wasn't yesterday. But somebody says they're looking for them recently released from jail. Okay. So this happened 4 years ago, right? Does she have a reason to be in fear now from an incident that happened four years ago? It's 4 years later. Drop it in the chat if you think she has a reasonable reason to fear for her safety. Oh, looks, I got kicked out again, but I'm back. Can you hear me?
Yes.
Okay. So some people say, you know, it was 4 years ago. You know, only she can determine that. There's no cookie cutter time frame to fear for, okay. Possibly, yes. If he had been incarcerated for that act. Okay, I'm seeing a lot of good conversation around if this is a current situation and is it going to impact her today, right? Somebody says absolutely. Let's move forward a couple of slides, Anne. One more. So the housing provider was in violation of the Fair Housing Act. If you could go back one, Anne. Because Anne was required to pay a fine to the survivor as well as complete a conciliation agreement. A conciliation agreement is an agreement with HUD. It's basically an agreement that outlines all the things that you will do to change your ways. You will do, you know, policies and procedures. You'll change all your policies and procedures. You'll train all your staff. You'll hire a VAWA coordinator. You will, you know, pay a fine, pay a settlement, and you basically won't do this again. And so a conciliation agreement can have many different kind of responses of what a PHA is supposed to do if they violate it. And it is a legal agreement, a legal binding agreement to solve a case. So in this case, Denise was denied housing and the PHA was required to pay, I believe it was $20,000 to the survivor. I'd have to double check that, but I'm pretty sure it was $20,000. And then had to provide her housing, right? Because she was allowed to keep the Social Security cards because she did fear for her safety and the safety of her children. So in the next slide, the Violence Against Women Act has been reauthorized in 2022, but it basically started to expand housing protections for victims. It was reauthorized in 2013 as well, but it's been around for 30 years, since 1994. It's one of HUD's core programs. And now what I really like about it, and some of you might not like about it, but I actually do, is that it has an enforcement arm. It falls under fair housing. They actually have a team of lawyers that are working on VAWA cases across the country. And it is to create housing protections for people who have been survivors of domestic violence, dating violence, sexual assault, or stalking. It is core to HUD's housing and homelessness programs. And individuals can't be denied admission or denied assistance because they've been a victim or a survivor in dating, violence, sexual assault, and or stalking. And it has expanded. So HUD has increased protections since 2022. And in the next slide, somebody said, what if they didn't have a Social Security number? Yes, that could potentially happen too. So VAWA applies to pretty much all HUD programs, all HUD housing programs. So there's not one program that it does not touch. In addition, VAWA falls under the Department of Justice as well. And states have adopted VAWA laws and tenancy protections, et cetera. So it even expands even further than what you see here that HUD is enforcing and requiring. And then the next slide. So who's covered? It's someone who's previously or currently experiencing domestic violence. And when HUD says previously, HUD is not putting a time frame on what previously means. So some people say, oh, this happened 4 years ago, you know, should she really fear for her safety 4 years later? We don't get to decide that. the person who's experienced the violence gets to decide that if they feel that they are currently experiencing or have, you know, real fears of domestic violence, sexual assault, dating violence, or stalking. They do not have to have been married or even related to that person or living with the perpetrator to be protected by a VAWA. So it does not matter how long ago the survivor experienced the violence. And also their immigration status in of itself does not impact a survivor's right to VAWA's housing protections. So they apply in part to a survivor if they're applying for or living in a shelter, transitional housing, or permanent housing. Can you go back one, Ann? As well as any federal homeless assistance program or federal affordable housing program. And it does not discriminate against gender. So it could be a male that is experiencing violence. So you could have a case of a male, and that has happened. So, or another gender orientation. So regardless of the sex, sexual identity or gender identity, sexual orientation of the person who was harmed and or the person committing the violence. So sex is not a factor, even though it's titled the Violence Against Women Act, it is the Violence Against People Act. And so it can be any sex. Next slide. Can't be denied admission to or assistance due to VAWA. You cannot be evicted or have your assistance terminated because of VAWA regarding the abuse committed against them. You also are not supposed to take into account some of the records, such as having an eviction record due to VAWA, criminal history, and or bad credit history, because often there's fiduciary abuse, which is financial abuse when you're talking about people who've experienced violence. And they must have an option to stay in their HUD housing, even if there's been criminal activity at the site. That's a big one, because you know, you get these disturbances, the police have been called, now you're disturbing the peace. If it's VAWA related, they must be allowed the option to stay. And they can also request an emergency transfer. This is a big thing, especially in small communities. This emergency transfer is like, where do we transfer them to? Do we have resources? I mean, you go through a whole drama around the emergency transfer. And VAWA is a huge training in of itself. So we're not going to be able to talk about all of it, but the bottom line is they must be allowed to move with continued assistance if they need to. And then the next slide. Somebody says EIN number, if they didn't have a social number. The point in this case is that they didn't have to provide the social security number or an EIN number or any other numbers, because HUD said that they didn't have to. So with the reauthorization, there's new implementation requirements. VAWA is now enforced under the Fair Housing Act, which means they actually have a team of lawyers that are enforcing VAWA cases. And which, you know, in the long run, it's a good thing. It is a challenge, though, to get the entire country up to speed on the protections. Somebody said, what about project-based vouchers? Yes, VAWA covers project-based vouchers. So at the end of the day, all HUD housing programs are covered under VAWA. And in addition, many states have their own protections as well. And in the next slide, fair housing and equal opportunity, right? So you have to affirmatively further fair housing. There has to be non-discrimination and equal opportunity requirements. This applies to outreach, admissions, implementation, and your ongoing assistance. Somebody says, what about child abduction and child trafficking? Human trafficking and commercial sexual exploited children are also covered under the Violence Against Women Act. It is not as forward in the law. However, they are covered. So human trafficking victims, child trafficking, and commercially sexually exploited children are covered under the Fair Housing Act, under the Violence Against Women Act. While it's not codified and as you know, pronounced in the law, I actually reached out to HUD directly and asked this question specifically around youth that have experienced homelessness, that have been trafficked. And yes, HUD responded and said they are covered under VAWA, as well as HUD has done a deeper dive recently. And there's some language out there that they've done a deeper dive on human trafficking and how it's related to domestic violence. So the answer is yes, they are covered. And in the next slide, we've got another case study for you. And this will be our last case study, and then I will pass it over to Anne, and then we'll leave a little room for questions because we know this is a lot to take in. You guys have learned a lot. I actually learned a lot in the first session around having to maintain a property. I'm like, oh my goodness, it's so much work to maintain these properties. I don't know how you guys are doing all of this. You got to maintain the properties. You got to maintain the people. It's a lot of work. So I commend you all for the great work you're doing across our country to house our most vulnerable people. And so we are moving on to the story of Darren. Darren came up on the Section 8 waiting list. Woohoo! We know those lists can be really long in many communities, right? So some people, I've waited 10 years. So anyway, he finally came up. So the PHA worker called to notify him of his eligibility, and he was ecstatic. He advised the PHA worker that he has his boyfriend who helps take care of him and 3 children that are in foster care that he's going to reunite with in approximately 6 months when he finishes his parenting classes. He requested a 3-bedroom to accommodate himself, his boyfriend, and his children. What should the PHA worker do next? And in the next slide, what should the PHA do next? Are you going to allow Darren to have a 1-bedroom for himself only? Allow Darren and boyfriend to have a 1-bedroom? Allow Darren to have a 3-bedroom because his children will live with him in the future? Or my favorite answer, ask a supervisor, and then that way you know you're always covered. That worked very well until I was the supervisor, and then it's like, darn it, I gotta figure this out. So ask a supervisor. I got a 4, 3. Sorry, the LOL. Number 2. Somebody's gonna give him the 1-bedroom, okay. 3, 4, ask the supervisor. Number 2, Darren and the boyfriend, confirm subsidy standard and request documentation of foster children placement. Somebody says, I think that's a 1-bedroom for himself only. Number 2, Darren and boyfriend. Okay. I'll give you guys a chance to answer, please. Put what you think it is. Yes, but for both of them. Confirm with the other agency of the kids' return. So these kids are coming in 6 months. Somebody says this wouldn't be for an elderly disabled, so this wouldn't apply in that case. Number 3, is he a live-in aid? Interesting. I'm glad somebody picked up on that. He said he helps take care of him. What are the requirements of the foster care? Recertify in 6 months. So give him the 1 or 2 and recertify. If they have proof, then 3. 2 for now and reevaluate when it gets closer to the children coming. I guess it depends on the inventory. I would do the recert. Number 2, 1-bedroom, then recertify in 6 months. Number 3, interesting. I didn't think about the recertify in 6 months. I like that. But are you guys all good with boyfriend moving in? Looks like Darren and boyfriend must have updated. Yes, yes. Boyfriend can come. Boyfriend / helper taking care of him. Yes. If he is on the original application, yes. Yes, but only if he's a live-in aid. Okay, confirm he's going to be a live-in aid as long as he meets the requirements and is a certified caretaker. Do you have to be a certified caretaker? That's interesting. Yes. No. Somebody says no to boyfriend. Sorry, boyfriend. Sorry, boyfriend, you're not moving in. boyfriend gonna be over there anyway? Yes. Sometimes we create these challenges for ourselves. Now he's got an authorized guest. Okay, yes, as a domestic partner, is he through an agency? He must do live-in aid documents. Got that. I understand that. The foster care given to him if he does not have a place for them. Boom. I love that, Richard. I did disagree with issuing the 1 bedroom because the research in 6 months, he would have to move again. Okay. Does Section 8 cover both of them, or is it just him? Reapplying in a few minutes. Foster care is not always prompt. No to certified caretaker as long as the letter is okay. Specific marital status isn't a requirement for family. You guys got a lot of great answers. Okay. Next slide, please. He must meet the requirements of a 3-bedroom at the time of applying. Heather says that. What if he doesn't get approved and you gave him a 3? Will he owe money back and lease signing? Okay. HUD's equal access rule. So under HUD's equal access rule, it was designed to ensure that HUD programs are open to all eligible individuals and families, regardless of their sexual orientation, gender identity, or marital status. Somebody mentioned that. Pride is in the best. You mentioned that in the chat. It doesn't matter if they're married or not, etc. The individuals shall have access to housing according to their gender identity. So in other words, if they wanted to be in some sort of gender specific place, they get to choose. There's no requirements to prove gender identity, and it needs to be provided in all HUD assisted programs, and providers must update their policies and procedures to reflect that you meet the equal access rule. What if he doesn't get approved and you gave him a 3 while he owes the money back? I see that in lease signing. Let's go into the next slide. So in 2016, HUD amended the definition to be more clear, to talk about people's gender identities, because that was an issue. So this is actually part of this case. And so HUD determined that there were significant barriers faced by transgender and gender non-conforming individuals and people when accessing temporary emergency shelter or other facilities with physical limitations, particularly when there were shared sleeping quarters and bathing facilities. But what was most important is that HUD found that transgender and gender nonconforming people continue to experience significant harassment, violence, and discrimination when in attempting to access programs, benefits, services, and accommodations. So in this case, and in the next slide, HUD created the equal access rule. And what does HUD define as a family? This means that any group of people that present together for assistance and identify themselves as a family, regardless of the age or relationship or other factors, are considered a family, and they must be served together as such. So in this case, that means boyfriend is coming, which in the long run may be better because they were already, a couple. You don't want to have to deal with unauthorized guests later because he's coming over there anyway. You know that, right? Like boyfriend's going to visit and he's going to be there a lot, and then it's going to be a drama anyway. So you might as well allow boyfriend to come in from the very beginning. Further, you cannot discriminate against a group of people presenting as a family based on the composition of the family, whether it's adults, children, or just adults. And you can't discriminate on the age of any family members, the disability status of family members, their marital status, their sexual orientation or perceived sexual orientation, or gender identity. In the next slide, HUD defines a family or a household that it means all persons occupying the unit. And this is actually a HUD poster that they recommend is listed in all HUD programs, that you have it in your intake areas. So household means all persons occupying a housing unit. You can be defined as a family, which could be 2 or more families living together, or even a group of people or unrelated people who share living arrangements, regardless of their perceived sexual orientation, gender identity, or marital status. So boyfriend is coming. All right, to the next slide. Family includes, but is not limited to, regardless of the marital status,
all of those things that we just mentioned, and including if they have a disability. So there's another layer there. And it also includes a child who is temporarily away from the home because of placement in foster care. They are still considered a member of the family. Now, this is a key point that I want to bring up here. He said, I'm going to reunify with my children within 6 months, right? He's finishing his parenting classes. What does that tell you about him? He's got to finish parenting classes. He's reunifying in 6 months. What does that tell you? Anything you want to mention about that? Somebody did already, but I want to see what you guys pick up on here. He's got to do parenting classes. There's a reunification plan. He had parenting issues. Yes, the children were taken away. There's a court order in place. Most likely these children are in the child welfare system, right? They've got to be in some sort of legal, situation for him to have to complete parenting classes for him to get the kids back. Okay. So if we know that, and if he has to go to court and complete parenting classes or deal with child welfare, is child welfare going to give him these kids if he has no place for them to go? Most likely no, right? So he needs the 3-bedroom to prove that he has a place for these children to go when he finishes these parenting classes. So in this case, the family stays intact. The boyfriend, you make space for the children. If he doesn't get the kids back, you give him time to try to get the kids back. And then at some point you can make a decision that he would have to, come from a 3-bedroom down to a smaller unit. But at the end of the day, you've got to honor the 3-bedroom unit for him and the kids. Now, there is that piece around, is the boyfriend a live-in aid? I don't know if I'd go there or address that. At this point, I would say, he's the boyfriend, right? They're most likely going to share a room together. Is he a live-in aid or he's a boyfriend? He's probably a boyfriend first, right? So I wouldn't worry about an additional room for the live-in aid, etc. So in the long but short story of this, we keep the family intact. Does that make sense? Yes, folks say yes. Some say it may not make sense, but we still have to do it anyway, right? Because HUD says we have to under HUD's equal access rule, which ties back to fair housing. So we keep the family intact. And we don't worry about all these other issues. His rent's going to be higher. He's going to have to do this and have to do that. We keep him intact. He asked for a larger place. We know that he's got children who need to reunify. Give him the place. Okay. You do what's right in this situation. All right. And now I am passing over to my good friend, my mentor, Miss Ann Denton. It's amazing. She's been doing this work like 40 years. I love her a lot. And she's going to teach us about Olmstead.
All right.
Dr. Hill,
Ann.
I'm sorry. And Dr. Hill, there's just 2 questions just regarding, one of them was about the poster. They were wondering
you want a copy of the poster?
Where they can get the poster.
Okay, I will drop it in the chat.
Perfect.
It's actually, the link is
Also
at the bottom of the slide too, but I'll drop it in the chat.
Perfect. That would be great. And then the other question is just regarding if an adult has very recent criminal history, we do have to do our due diligence and act on the findings based upon our policy.
Yes, that is true, but you need to take into consideration HUD's recent guidance around criminal prohibitions, because HUD found that the criminal prohibitions are discriminatory in nature because often they're related to disparate populations that are being discriminated against based on race, okay, and often gender as well. So if you have criminal prohibitions in place, you need to review HUD's most recent guidance around criminal prohibitions, and I will drop that in the chat as well.
Okay. Perfect. Thank you.
You're welcome.
I'm
All
sorry,
right.
Anne.
All right. Well, thank you, Demi. That was fascinating. And I love the case studies, and partly because several of them relate to disability. And that's what we're going to be talking about for the next little bit. And Demi already introduced me, and I don't like that picture, so we're going to move on. The Olmstead Supreme Court decision was handed down in 1999. And it basically says that community integration is a requirement of the ADA for people with disabilities. And that was preceded by Fair Housing Act and Section 504 of the Rehabilitation Act. And if you have extra time, I would recommend a movie called CRIP Camp, C-R-I-P Camp, which is really the story of one of the paths of disability rights activity. One of the ways that movement began. And it is also the story of the passage of Section 504 of the Rehab Act. It's a great movie. So anyway, the Olmstead decision is well-based in other laws, previous laws, and HUD has been on board from the beginning. In multiple guidance documents, HUD, and again, like I said earlier, the Department of Justice have worked together to make sure that options and possibilities for people with disabilities continue to expand, and that it definitely includes housing. So here's a little bit more about the Olmstead decision. One of the things today, I'm so old, Demi said I've been doing this for 40 years, and sadly that's true. And one of the things I do, I go all across the country and talk about stuff all the time. And when I get a group of younger professionals, sometimes I'll say to them, what's Olmstead? Who knows what Olmstead is? And not enough people raise their hands, in my humble opinion. So just take a minute and look at that Olmstead is about many things, but primarily of interest for people with disabilities and for this audience is integration. The Supreme Court said that people with disabilities have a qualified right to receive state-funded, publicly funded, supports and services in the community rather than institutions when these three things are in place. One, the person's treatment professionals determine that community supports are appropriate. Two, the person doesn't object to going. And three, the provision of services in the community would be a reasonable accommodation when balanced with other similarly situated individuals with disabilities. Now, what does that mean in non-lawyer talk? And what that means in non-lawyer talk is that if a person is clinically ready to be discharged from an institution, if it's a physical disability, they've achieved their rehabilitation goals, whatever. For persons with mental illness or behavioral health disorders, it means that they are clinically ready to go. They're stable on medication, whatever definition that is. The person doesn't object to being in the community. And, you know, I've worked for many years with Centers for Independent Living and people in behavioral health, publicly funded systems. And really, most people are ready to go. They will have no objection to leaving a state hospital or leaving a nursing home to live in a community. And then this thing about the provision of services in the community is a reasonable accommodation. Yes. So if the system can put together in the community a set of services and supports designed to meet this person's needs, then it must occur. Can't just say, well, we don't want to do it, right? Or it's too complicated. That's what we hear sometimes. Home health doesn't want to take somebody on because their disability requires significant levels of care. Okay, that's not an excuse for keeping someone in an institution. It's not an acceptable condition for institutionalization. Okay, so this is the actual language around segregation. So Title II of the Americans with Disabilities Act talks about the unjustified segregation of individuals with disabilities. And that means that Remember, I was excited when people said that we had disability is a protected class. Disability is a protected class under fair housing and the ADA. And it's prohibited. You can't treat people differently. Why is Olmstead important? Right? Well, Olmstead's important, one, because we're all required to comply. It's the law. Starting with that Rehab Act, Fair Housing Fair Housing continues it. The Fair Housing Amendments Act actually added disabilities, and the ADA all reinforce choice and self-determination. The second reason that this is important is community integration supports health and wellness. Affordable, safe housing is a powerful determinant of health. So in my world, social determinants of health has become a really important factor in thinking about how do you construct public systems to provide services and supports and housing for people with disabilities, because all of those things together predict someone's health and wellness. The importance of housing, I don't think the importance of housing can be overstated. If someone has a safe place to live, what that means is they have a place to store their medication if they take medication. They have a place to eat meals, healthy or not, they're eating. They have a place to take care of what we call activities of daily living, grooming, showering, they have a safe place in which to be a fully functioning adult, a boyfriend, a girlfriend. They have privacy. They have all the things that I believe that all of are important to everyone. That housing and all of those factors that housing allows predict people's ability to, things like whether or not that people recover from illnesses, how long it takes people to recover from illnesses, the incidence and prevalence of health complications is demonstrably linked to housing and availability of services. So it matters because it's the law. It matters because people do better. And it matters because it's the right thing to do. So I wanted to just take a minute and just talk about legal actions that have been related to Olmstead. And many of these are based in following federal investigations and their class action lawsuits. Many of them are focused on the behavioral health system. AHP has worked for a long time with states that are under settlement agreements. And those settlement agreements, in my observation, is they almost always include that the individuals must have access to affordable, accessible, integrated housing. So if you are in any of these states, and many of you, there's so many attendees, I'm sure some of you are, you may or may not have been involved in some of this, but the legal actions, the federal government has taken an active interest in enforcing the provisions of Olmstead. Yeah, we're actively working right now with a state that has two actions, one around people with developmental disabilities and one around people with behavioral health disorders. So who's interested? This is, I've already said this, but it's HUD, DOJ, and Department of Health and Human Services. So I want to back up for a minute and talk about the Rehabilitation Act of 1973. Demi had a slide earlier which laid them out, 1, 2, 3, 4, 5, 6. This is how the laws went. But 504 of the Rehab Act was groundbreaking in a way, and all of the others followed from Section 504. And this is where the language most integrated setting comes from. It prohibits discrimination against people with disabilities in federal programs. So it was narrower than the later ADA and fair housing. But when we're talking about most integrated setting, that does not include nursing homes, group homes, anything where people are separated from the community. I should have put a quiz in there. So just recently, there was a final rule issued on Section 504 in May of 2024. It took a little while, from 1973 to 2024. And what this final rule on Section 504 did was it fixed a lot of the problems that were in practice that had a discriminatory effect. And Demi touched on this. And one of the things that that has emerged over this last couple of decades is that if a practice has a discriminatory effect, whether or not the discrimination was intentional, that practice becomes actionable, right? So if you have a provision that says people with disabilities have to come to you, I'm just making this up now, but people with disabilities have to bring an extra paperwork to prove that they're quote unquote capable of independent living. And that is not allowed, right? Because what you're doing is you're slowing down the process for those individuals. You're treating them differently, which is one of the discrimination no-nos that Demi talked about a few minutes ago. And it has a discriminatory effect. It keeps people out. It's a barrier. So what the final rule did here is it eliminated a lot of stuff in medical treatment, which I found interesting. There are things like, for someone with a physical disability, medical equipment may not be adaptable to their specific condition. And this fixed that, so it has to be adaptable. And then the value assessment. Can anybody think what a value assessment might be in this context? I'm going to stop and let you think about that. We're talking here a little bit about, so this is in the medical world, right? So discrimination in medical treatment, accessibility of medical equipment, and value assessment. And I can't figure out how to read the questions, so without showing them to you.
We don't have any answers in there right now.
Okay. I'll give it a second. So the short version of it, which is really nasty, right? The short version of it is that a doctor or a medical professional may look at a person with a disability, maybe a significant disability, and think, well, if it was my mother, I would recommend that, this treatment and this treatment and this treatment, and let's try 5 things to address this condition. But this person looks to me like their quality of life is not good, in my opinion. And so I'm going to offer them fewer options. I mean, I kind of knew that was going, you kind of know that that's going on, but to read it in the final rule, they don't put that in there if it's not happening. And I was aghast. Anyway, so the final rule on Section 504 fixes that and says that it is prohibited to make those kind of value assessments. that if you have, like, say, cancer and you're offered radiation or chemo or immunotherapy or whatever other options there are, if that's the protocol, then that protocol has to be offered regardless of whether or not a person has a disability. Okay, I've shared my horror about that. I'll move on. Then
Sorry, there is one question just about, what about costs to modify units?
what about cost to modify what?
Units.
The unit?
Mhm.
That really hasn't changed. So it's the whole reasonable accommodation, reasonable modification. So that has not changed. So if somebody needs a modification, that modification has to be provided. The cost, though, is more frequently borne by the person, unless there's something extraordinary going on.
I can jump in here, Anne, real quick.
Sure.
So if you're asking about the cost to modify a unit, you have to determine what's considered reasonable. So is it a grab bar in the shower? Is that reasonable? Yes. Is I need an elevator to get to the third floor reasonable?
No.
Yeah, no, that's probably not reasonable. And that person probably needs to move to another unit that would be accessible. So you have to think of it in terms of what reasonable people would think, right? And do to support somebody with a physical disability that needs access to a unit or a housing, basically an apartment or a unit or a house. So if it's reasonable, the cost should be covered by the Public Housing Authority if it's reasonable. If it is exorbitant, then it can be contested, but the goal is to support people who need these accommodations in the best way possible. And somebody says cost is covered if reasonable by the PHA. Yes,
Right.
that would be a yes.
Yes. I have heard though, because of the work in the disability, that sometimes the cost of modifying it back to its previous condition can be contested, and the person with a disability can be asked to pay part of it or all of it. Okay, so community integration. So the final rule on 504, again, decades to get there. Again, primarily or largely around medical treatment, but it also reinforced the Olmstead decision and emphasized that services and activities must be provided in the most integrated setting possible, including their housing. So that's section 504. So let's go back to the HUD guidance. So this is HUD guidance on Olmstead. And this is old too. It's 2013. So in June of 2013, HUD issued guidance that encouraged housing providers to support Olmstead implementation by increasing access to integrated housing. And it emphasized the sort of the value-based imperatives around choice and self-determination, and made a commitment to, on your behalf, to offering people with disabilities housing choices that are meaningful and real, in terms of the housing that they can. So an example of that is someone wants to be eligible for housing programs, and maybe you have a housing program that is that was developed and built for people with disabilities, and then you have all of your other housing programs. If the person chooses to live and wants to sign up for the waiting list for the single site program, then that's great. But if you make the determination that this person has a disability, so they have to go on the waiting list only for that unit, you're not in harmony with HUD's guidance on this. HUD and DOJ have done, and the Administration on Community Living have done a lot of work over the decades around trying to increase the stock and increase access to integrated housing. And one of the things that they did was they used the mainstream voucher program. This is what my friend Ann O'Hara would call a HUD boutique program. In other words, it's small, or has been small historically. It comes out of the old Section 811 program. And so they pulled some of the resources out, and it's now the mainstream voucher program. And then the Section 811 program itself has been modified and adapted. So they took this funding stream and basically broke it into two: mainstream vouchers, and then the 811 program, which really now can support the development of integrated multifamily housing projects. The dollars can be used to project base up to 25% of the units in a multifamily housing development. So there are three actually opportunities here, and all of this came historically from the 811 program. But the three opportunities are the mainstream housing voucher program. The second one is investing. You can invest in the project. So you can use project-based rental assistance to invest in the development of integrated multifamily housing. And you can also, number three, build old-fashioned Section 811 units. Just to make sure that everybody knows what I'm talking about, which is the 811 program many decades ago only they built single site programs. Every unit in the program was targeted for someone with a disability. So if you have someone who has a disability and who is looking for housing, all three of these things offer choices for them. So
I'm sorry, and we just have a couple of questions. One of them is regarding, is this for physical disability or emotional disability?
It's for all disability. So physical disability and like Demi's slide earlier, visible and invisible disabilities. And so if someone with a serious mental illness, that's not as visible as someone who's using a wheelchair. But it's for all disabilities.
And then this is more of a specific question, so you may not have an answer to this, but it was, we do not have storm doors, only the entry door. Tenant has severe anxiety, is asking for a glass storm door so she can leave it open and be able to see outside. Do we have to provide a storm door for her?
I don't know. I mean, I don't know. I would say that it warrants serious consideration. And I would say that if the need for the storm door is directly linked to a disability, then a reasonable accommodation should be granted. Back to Demi's slide earlier, the one with the pretty orange background. You know, we're in the business of housing people. So let's do what we can to keep them housed.
And would it be a huge administrative burden to, how much more is a storm door? Is it, super expensive? Is it cheap? I mean, you have to go through the process of determining what would reasonable people think. Is this a huge burden on the PHA to provide this? So if you could provide it, I would, if that's going to make this person's life better. So I think in this case, I probably would lean towards providing it.
And then there's another kind of question along that same line. For someone with asthma, would installing allergy type filters with better filtration for fine particles in a heating and air conditioning system instead of low efficiency panel be a reasonable accommodation?
I think that could be considered reasonable. It's not going to be a huge expense to provide a different type of filter. I do think that could be considered reasonable, yes.
Okay. Sorry, thank you. Those were the questions that have been coming in.
Very cool. All right. So HUD has issued new guidance, just hot off the press, really, August of 2024, And it's around the mainstream housing program. So the new guidance is a way to make this program work better for people with disabilities and to make the whole process easier for prospective tenants. This is part of under the Biden-Harris administration, HUD had already expanded the mainstream voucher program by more than 20,000 vouchers and awarded additional extraordinary administrative fees. And since 1997, HUD awarded over 500 million in funding to public housing agencies to support 71,000 mainstream vouchers. So it may have started out as a boutique program, but at this point, it's a significant underpinning of our response to Olmstead and the ADA. So the new guidance, well, part of it is about the housing search. So one of the huge problems for people with disabilities is they have, sort of a double whammy of many people are on a disability income, which means they are poor, okay? And then the other thing is they may need a physically accessible unit. So when you take, if you did a little Venn diagram of physically accessible units and affordable, the sliver of those units is pretty small. And so it takes a minute to find a unit that, one, the landlord participates in, in programs with you, two, is physically accessible, and three, is affordable to someone on a disability income. So the minimum initial search term automatically increases to 120 days, and the initial request for a 90-day extension is basically mandatory. You have to grant that. Also, PHAs can't impose a residency requirement because they may leave an institution in your community, and where they can find that affordable, accessible housing may be in a different community. So these are two significant provisions designed to make the search easier for people. The other thing that the new guidance does is it allows PHAs to adopt to create a separate waiting list. You don't have to, but if you have a high utilization of your mainstream vouchers, you might not need to do that, but you might choose to do so if it makes the process more streamlined and easier to access from the perspective of the person seeking housing. Keep moving y'all around because you're on. More guidance around the mainstream housing programs. You may, don't have to, but may adopt admissions preferences that prioritize direct referrals from your healthcare and disability partners. So in the community where I spent most of my career, which is Austin, Texas, we have a organization there that basically on behalf of the community sort of gathers and gathers names and does outreach to people with disabilities and assists them in making these applications. And what this new provision does is it would allow the local housing authority to prioritize direct referrals from that organization if they wanted to. As long as it's cross disability. I mean, that's the other thing when we were talking about the Fair Housing Office at HUD. One of the things that is loud and clear and different from the practice when I started my career is you can't do disability specific housing. So I can't, do an apartment. I can't do a preference list for people who have hearing impairments only, right? For example, any kind of preference or any sort of different procedure covering people with disabilities has to be cross disability, any person with a disability, any disability. And then you have this flexibility to adopt those preferences, either only for your mainstream voucher program if you're operating a separate list, or for your overall program. And that is it.
Thank you so much, Anne. Let's see if we have any comments or questions. And that it could be with regards to anything throughout the session. Oh, I'm sorry, there was a question regarding the name of the movie that you mentioned, Anne.
Okay.
If
It's
you
called,
could provide that to us, we're gonna put that in the chat.
okay, it's called CRIP Camp, CRIP Camp, CAMP, CRIP, short for cripple.
Perfect.
Not
thank
making that up. You should watch it. You'll see why.
And then someone commented and said, I thought we could not have a separate wait list for mainstream.
Yeah, the new guidance says you can.
Perfect.
For Olmstead.
For main, yeah. Yeah.
So
Right here.
then we also had a comment regarding that this that all of the attendees are not public housing. So maybe
Okay, sorry.
if Dr. Hill or Ann, if you could kind of comment on how the act applies to those in the affordable housing realm, and how those could be separate, or if there are any differences in how it applies.
I mean, the people who are seeking affordable housing in general, all the provisions of fair housing, all the provisions of ADA and Olmstead apply. So any practice that like say a property management company has some sort of a practice that has a discriminatory effect on persons with disabilities, it makes the process longer or more difficult, or they have to have extra insurance or an extra deposit, or whatever. It doesn't matter that it's not a PHA. That is still prohibited.
Agreed.
I think that is
Any-
everything.
Any other questions around fair housing or anything that we chatted about today? This is your time. Floor is open. We also put our emails in the chat if you need us for anything. We often get calls and emails after the fact of, oh, we've got this one case and we've got to try to figure this thing out, right? So we left our contact information in the chat so that you can reach out to us if you need to. But at the end of the day, we hope that you guys had an opportunity to learn something new and reinforce what you already know, because I know you're the brightest and the best. See what we got here. Can you have an apply only online policy? I would probably not, just because that could be considered discriminatory in effect, because not everybody has access to technology, right? You want to make sure that you're marketing to all groups of people, and an apply only online will limit people who do not have access to technology. They may not have a phone, they may not have a computer. And so then you're not serving certain populations, and that could be discriminatory. It could be a discriminatory impact.
Right.
So I would not have an apply online only policy. Now, could you have apply online, apply in person, apply by mail, all these other ways? Yes. But not only. I would not. Somebody said they need a follow-up on the epilepsy seizure question earlier. Okay, we have to find that.
I think it was in the chat, so we're unable to search through it. So if Shirley, if you could type it, retype it, that would be great, please.
While we're waiting for that, I just want to say one of the things that I've always found to be the case, mostly found to be the case, is that when people are writing a rule, right? Like, there's a person who maybe uses walking sticks, right? To move around, and they can go up and down stairs, but it's scary to watch. And you have had a unit open up, but it's a second floor unit, and they decide they want to take it. Sometimes our desire to protect people from themselves might cause us to caution that person or push back on that person and advise them to wait for a ground floor unit. But sort of the dignity of risk and the law say that people get to decide. So do we get the question on epilepsy and seizures?
I don't,
believe
s- yeah, I don't see that one, but I do see, does digital equity come up in this fair housing realm? So here's the thing. I haven't seen specific language on digital equity, right? Because that's kind of a newer thing when we talk about this technological age. However, fair housing does apply to outreach, admissions, and marketing. So you have to market to vulnerable groups. And to be able to do that, you need to be able to do that in a compendium of ways, right? That means, connecting with disparate communities. As you know, many seniors aren't technologically advanced. So you want to make sure that everything isn't, we have to have a computer and we've got to have a phone. You got to have different ways that people can connect to your outreach and marketing to meet fair housing and to affirmatively further fair housing. And that is something HUD does talk about and is required. So it's not optional. It is something that you should do. If you're administering HUD programs, you have to affirmatively fair market your programs.
And we do have the question, the restrictions
Okay.
on asking about a disability make it difficult for property owners. As an example, we have a tenant that has epilepsy seizures and it makes it difficult to minimize risk. Or even ask if they need to wear a helmet to protect themselves. This tenant has fallen on multiple occasions with various levels of injury. How can we keep the tenant safe without minimizing our risk? While minimizing our risk.
That's a complicated case, right? You're talking about a tenant, you're a houser, your job is to house people, you're not a social worker, right? You're a housing agency or housing specialist. You're somebody whose job is to pay the rent, right? It's not necessarily to do the social services component. So in this case, I probably would want to refer them to an agency that can help support them in this way, because you got to stay in your lane, right? Your job is not to be the social worker. Your job is to house them and keep them housed. And there's other agencies that specialize in this area. So maybe think about who you could partner with to help and make a referral to, but also they have to be willing to accept that referral, right? As well, and be willing to want to accept that referral. So it's complicated. At the end of the day, your job is to help in the best way possible. But people have free choice and free will too, if they want to be involved in those type of services. So I probably would try to encourage them to take the referral and then let that agency step in and do the job they're paid to do, which is the social services aspect.
Okay, great.
I hope that answers your question. I know it's tough. We want to help people, right?
I don't see any other questions or comments. I want to thank you both because it was such an excellent topic. Love the case studies and all the examples. We do apologize for some of the technical difficulties at the beginning, but
know.
we worked through it. We got it. So we do appreciate both of your time and all of your extensive knowledge on this topic. And please feel free to reach out to them because they are amazing, great resources for everyone. And I do just want to mention that we do have our cybersecurity session, which is a very different topic from what we just spoke about, but one that is important as well. That will be starting right at 1 o'clock. So you will have a link to that in your emails. So we appreciate everyone sticking with us, and we will see you at 1. Thank you again.
Thank you.
Thank you so much, Beth. Grab something to eat while you can. Get a snack.
Definitely.
Come back at 1.
Thank
Take care,
you.
everyone.
Bye-bye.
Thank you so much.